Dr. Abdul Karim Lahiji, Vice President of the International Federation of Human Rights League, has attempted to bring an international case against the Islamic Republic of Iran since the creation of the Rome Statute. Dr. Lahiji worked extensively to document and investigate the assassination of Dr. Ghassemlou. It might be possible to present a strong case if the assassinations were brought forth along with the other instances of aggression in order to demonstrate that the Iranian government lacks regard for human dignity and the right to life. The most significant challenge in bringing a criminal case before the court is the jurisdictional reach of the ICC, which can only prosecute crimes taken place within signatory nations or prosecute a person who committed such crimes within the boundaries of a signatory nation. This simply means that unless the crimes persecuted against the Kurds took place in a country like the Netherlands, the court would not be able to prosecute the case. The court then becomes entirely arbitrary because leaders of non-signatory nations like the IRI can commit crimes within their territory without fear of prosecution. Only if the UN Human Rights Council refers a case to the ICC can the court prosecute a non-signatory nation. Being able to convince the United Nations Security Council to take such a profound action against the Islamic Republic is not an easy task, especially because the process is highly politicized by the permanent member of the Council. Despite recent increased diplomatic pressure on Iran, including sanctions, Islamic Republic of Iran has refused to cooperate or allow inspections of state prisons. The politics of nuclear negotiation has complicated the international community's commitment to human rights. Even if, against all odds, the Security Council decided to bring a case against Iran at the ICC, there would be the issue of diplomatic versus international prosecutions. The ICC is intended to complement existing national judicial system and can exercise its jurisdiction only if national courts are genuinely unwilling or unable to investigate or prosecute such a crime. Advocates would have to argue that the IRI's judicial system is incapable of carrying out an unbiased investigation into allegations of human rights abuse due to the simple fact that courts and judges in Iran are arms of the system's executive branch and operate based on their interpretation of Sharia law. The court's legitimacy is wholly dependent on the cooperation of states, which is rarely, if ever, present. The basis of most international law revolves around the notion of statehood and state rights. The Islamic Republic of Iran argues that they are not operating outside the state's existential imperative to condemn activity they perceive as threats to national security, although this is controversial and is serious need of revision. The burden of proof will fall on the victims, who are in this case members of the stateless people without protection or representation at the United Nations. Lack of statehood is also precisely why courts are not able to bring forth a case before the International Court of Justice. This court's role is to settle, in accordance with international law, legal disputes submitted to it by states and to give advisory opinions on legal questions referred to it by authorized United Nations organs and specialized agencies. Since ethnic and religious communities are not considered nations, they do not benefit from the protection of the ICJ. Other avenues of international criminal investigations and prosecutions. Ad hoc tribunals present the law intensity war against the Kurdish population in Iran as a mass atrocity. Investigations and prosecutions are ad hoc tribunals. These tribunals, however, have the statute of limitation, which means they are subject to time and locations constraints. Thus, they cannot prosecute retroactively. Although the law intensively war against the Kurdish population in Iran is continuous, many of the most horrendous acts were carried out within the first 2 decades of the Islamic Republic's birth. These acts should not go unpunished, and therefore an ad hoc tribunals, for example, an investigation into the crimes after the 2009 election will not sufficient. Two other possible avenues for justice: universal jurisdiction, responsibility to protect. Advocates can seek to bring forth a criminal case against the Islamic Republic of Iran at the domestic superior court of countries who take on such cases. Courts in Spain set historic precedents by famously taking on international criminal cases. This is based on the principle of universal jurisdiction, which states any national court may exercise criminal jurisdiction over serious crimes against international law, such as crimes against humanity, war crimes, and torture, based on the principle that such crimes harm the international community or order itself, which individual states may act to protect. Convincing a third-party country to take on a controversial case against the IRI at a domestic court is nearly impossible due to each country's economic, political, and security concerns or ties with Iran. Instead, advocates might need to make a strong case for the inclusion of human rights concerns as a bargaining chip during nuclear negotiations with Iran. Increased pressure on lobbyists and a special interest group would be needed to communicate the public's demand for a trial. A relatively novel but increasingly prominent idea in international law is the responsibility to protect, which is a new international security and human rights norm or set of principles based on the idea that sovereignty is not a privilege but a responsibility. Responsibility to protect focuses on preventing and halting four crimes: genocide, war crimes, crimes against humanity, and ethnic cleansing, which it places under the generic umbrella term mass atrocity crimes. Although responsibility to protect is not a law, it does provide a framework for using tools that already exist, like mediation, early warning mechanism, economic sanctioning, and Chapter 4 powers to prevent mass atrocities. Kurdish advocates can use these concepts to indicate the need for greater international pressure on the Islamic Republic of Iran, arguing that not doing so will allow for the continuation of an already dire condition for the Kurdish population amounting to mass atrocity crimes. Since both of the above concepts are criticized as infringement on state sovereignty, a very strong campaign would be needed to convince the international community to act. And on a final note, atrocity, impunity, and complicity, and international collaboration. The leniency shown by the international community in the face of IRS crimes is a reflection of powerful political agents, which often override the demand for justice, accurately pointed out by the Iran Human Rights Documentation Center, which indicates there is substantial evidence suggesting that the governments of several European states were negligent, if not reckless, in fulfilling their duty to provide effective remedy following the murder of Iranian dissidents within their jurisdiction. The evidence that Dr. Ghassemlou's murder was an unlawful execution by members of the Iranian government is overwhelming. Since Dr. Ghassemlou's murder, there have been dozens, if not hundreds, of well documented but unresolved extrajudicial executions in the diaspora. The 1992 Mykonos restaurant assassinations of Kurdish leadership is further evidence that the Islamic Republic of Iran is systematically targeting Kurdish intellectual and political figures in order to suppress Kurdish ambitions. All this is taking place outside of Iran in the sovereign soil of another nation with ease and anonymity. What is perhaps most tragic about remaining silent in the face of state-sanctioned crimes is that we leave people without any place of safety or sense of security. Dissidents and political refugees seeking asylum abroad find themselves unable to reach peace. They are faced with the reality of a life full of fear, intimidation, terror, extortion, and even death. Many have witnessed their colleagues disappear or their property arbitrarily destroyed. To treat these crimes as isolated and negligible acts would be to entirely diminish the importance of human rights. It leaves citizens of every nation at risk and open to attack by countries that choose to live outside the law. If state sovereignty is important to Iran, it should also be important to nations where these attacks are taking place. What must be loudly and clearly communicated to the world is the fact that impunity for crimes perpetrated by the IRI is not just a Kurdish issue, but rather an international threat. Crimes like this should be looked at as an international crisis that merits direct and swift action. The fact that Iran has been able to carry out such crimes for 30-some years without consequences, diplomatic or otherwise, should be considered a crime of complicity. Thank you all and have a great day.